We have allowed the writ appeal by setting aside the judgment of the learned single judge. But the writ petitioner have been granted liberty to approach the appropriate forum and establish their right if so advised, if any. But here, no right could be established.
Fine. Deeply okay. All right. Yeah. Before that, if your lordship permit me, a contempt petition was filed on 21st. I will just pray that Monday it may be.
Let's sit on Monday.
Yes, your lordship. In item number 5, I'm praying for an adjournment.
Why?
Mr. S. Bodhakur, he's out of station. He's the counsel who's leading us in this matter, my lord.
It is stated that the leading counsel, Mr. S. Bodhakur, is not available today. And thus the matter may be adjourned. List of 4 weeks.
Much obliged.
May please, your lordships. In the
Yes.
concern of the other side, I would like to mention item number 13. Lordship, the engaged counsel for the respondent is out of station.
Adjourn. Adjournment slip. No
Yes,
objection. Adjourn. 4 weeks. Yes.
May I please, your lordship, I beg to mention item number 16, lordship, with consent of the other side, lordship. There may be adjourned for the day only, lordship.
Writ appeal number so and so. As prayed by counsel for the appellant list of 4 weeks. Adjournment slip has been circulated.
With the consent of the other side, may I please mention item number 17, my lord?
17, same order, 4 weeks.
Deeply.
Your lordship, I'm also praying for an adjournment in item number
19.
19.
4 weeks.
Much obliged.
Okay.
May I please, the lordship, in this case, item number 23, I pray for some more time to file our objection, lord.
Okay. Counsel appearing for the respondent prays for and is granted 2 weeks time to file objections to the prayer for condonation.
Yes, your lordship.
Okay, 2 weeks.
And for the petitioner, lordship.
Name of the so and so shall be displayed in the call list henceforth.
That.
Item number 1 of daily list for motion.
Wait, please, lordship.
Notice will go to whom?
All the respondents, my lord.
All.
My lord.
Why all? Who is the concerned authority?
Despite giving an undertaking before this honorable court, my lord, they are not complying with the order. In the earlier.
Why all authorities? Why the principal secretary? Why? Tell us the officer responsible. Who is the officer responsible?
All are combinedly responsible, my lord, they took a decision, my lord.
Maybe we can issue notice to the 4, 5, and 6. Yes. You know? Heard issue notice to the response numbers 4, 5, and 6. Rule is made normal in 6 weeks.
My lord.
Item number 2.
May I please, your lordship.
Yes.
I am appearing on behalf of Mr. M. Ali, lordship. This is contempt petition to comply the order dated 18/2/2021. Page 13, lordship.
Contempt. Serious contempt already. Notice given. Despite that, no, they are not complying. We'll direct personal presence. Straight up. The writ petition number so and so. Writ appeal number so and so. Referred by the petitioner was accepted by order dated 18/2/2021, granting relief to the petitioner herein. First of, the order passed by the appellate court by the division bench was not complied with, whereupon, the petitioner filed contempt petition number so and so 406/21, which was disposed of by the order dated 22nd September 22, directing the respondents to comply with the directions issued by the division bench by 30th November 22. Till date, the compliance has not been made, on which the instant contempt petition has been filed. Issue notice to the respondents requiring them to remain personally present in the court on the next date of hearing. Listing, re-notify on 20th April.
Much obliged.
Item number 3,
May please, your lordship.
Yes.
Lordship, before going to the impugned order, lordship, I would like to mention the brief fact, lordship. Lordship, here, the petitioner is the land loser's lordship.
Yes.
Lordship, land was acquired for the railway project, lordship. And then in the railway, there is a policy, lordship, in the year 2010 for offering an employment, lordship.
Policy was withdrawn
Yes, lordship. But-
before the date of acquisition.
Yes, lordship.
Then
But in my case, lordship, my land has been acquired, taken possession by the respondent before withdrawal the notifications, lordships. That's
that
why,
is a disputed question of fact.
lordship,
Okay.
lordship, in this regard, lordship, I have submitted a judgment. Honorable Supreme Court said, lordship, when the respondent took possessions over the land,
Hmm.
on that day, lordship, the ownership
What is the finding on this aspect by tribunal?
tribunal is say, lordship said, lordship, they, lordship misinterpreted the,
Finding on possession.
yes, lordship, as per position point, lordship is admitted, lordship.
Where do you read that from?
Lordship, page, kindly come to page 167, lordship, and relevant part,
Yes.
lordship. Lordship, para 7, page 172.
Yes.
Lordship, it has been, it has been further stated by the applicant that the Honorable Apex Court in the case of Indoor Development Authority versus so and so, civil appeal number so and so, has held.
Sir, we are asking you, where is the finding that possession was taken before coming into force of that notification
Lordship,
or before the acquisition? That is your case.
yes, Lord.
Where is the finding?
Lordship, in this regard, Lordship, tribunal,
This is simply the allegation. What is this material to support this? It is noted. Yes.
para 9, Lordship.
This is simply his case.
Lordship, para 9, Lordship.
That is your submission, Mr.
No,
Counsel.
Lordship, in next para, Lordship.
Yes.
Para 9, it is noted that as per the applicant, Lordship, since the positions of the land was already taken and before withdrawal of the notification dated so and so, therefore, our case is covered by the notification dated so and so. However, it is also admitted fact that no notifications under the said circular has been issued inviting any applications for the land losers, and therefore, even if the applicant would be guided by the said notifications dated so and so, but unless and until the respondent would issue.
Mr.
In-
Counsel, we are asking you, where is the material to support this averment that you were in possession? Is it in the reply of the respondents before tribunal? Read.
Lordship, kindly come into page 38, Lordship. This is documents, Lordship, handing over and taking over possessions of the
Yes,
land.
show us that.
38, Lordship.
Yes,
The first line, Lordship, we have on 16th day of September
yes.
2019 handed over taken over the positions of the land specified in the
Issue notice. You are appearing for all respondents. MS so and so appears for all respondents. And thus, no formal notice needs to be issued. Are you prepared today?
No, I will file reply.
She prays for and is granted 4 weeks time to complete her instructions, public file reply if so required.
Highly obliged, sir.
Item number 4 for admission.
Yeah, sir.
May it please the Lord.
Yes.
My lord, in this case, we have challenged the virus of a week, my lord. What happened, my lord? In the Directorate of the Assam Town and County Planning, my lord,
Yes.
earlier there was a service order. Under that order, my lord, the feeder post for the post of director was from the service side superintending engineer. From the planning side, it was joint director.
Yes.
And similarly from research wing also, there was a scope.
Yes.
Now, my lord, they have come up with a new rule whereby, my lord, only planning branch can reach the stage of director, other two branches cannot. So challenging that, this petition was filed. My lord, where Advocate General of the state appeared and made a statement that, my lord, they're trying to reconcile the issue amongst both.
So
the
we can admit the writ petition, otherwise it's
Yes. Lordship
pending
will
since
admit it.
2016.
Meanwhile, my lord,
Admit, the respondents are duly represented, thus notice need not be issued. Pleadings are also complete.
yes.
List for
My
hearing.
lord, there was some from the government itself, an initiative was taken. If that could be carried forward, or else lordship will have to
the-
decide the issue. My lord.
In fact, my
Consideration of the issue on the administrative side as indicated in the previous order sheets
Yes.
shall continue.
Yes.
particularly 4/4/22, man.
Diploma.
Item number 6 to 8.
Interest
But I'm appealing for the respondent.
statute. Yes.
Sir, I'm appealing for the respondents in items 7 to 8. 7 and 8. These appeals have been filed by the Coal India Limited. and-
Not in 6. You're not in 6.
6 also. Six.
Yes.
6 the appellants.
Yes.
6 is the appellant. Six we are appellant. Yes, in 6, I am the appellant.
Okay.
Well, may I give a brief resume? I had filed 2 writ petitions pertaining to 2 contracts relating to the imposition of liquidated damages and termination of the contracts.
Right.
My both petitions were allowed. The impugned orders passed by the Coal India Limited were set aside. In one writ petition, my lord, I had not prayed for the grant of interest.
So you filed a review.
No, in one I had not prayed for the grant of interest, but in the other I had prayed. And then I filed a review application, which was dismissed. So I am in appeal against that order dismissing my review application relating to the grant of interest.
Right.
And Mr. Ahmad is in appeals, again, in 2 appeals against both the petition judgments where his actions have been set aside by your lordships.
So all right, we'll admit the appeals.
Well,
All
may-
three.
may I make a humble
Yes.
submission? Well, this is my 7th or 8th visit from Delhi. Your
Honorable the
Lordship
Chief
may
Justice of
set
India.
on For hearing.
Honorable the Chief Justice of India has made it very clear that now the concept of benches is no longer in vogue. Council can argue from wherever they are. We have the facility. You can address the court from Delhi. We don't have any issues.
My lord, first of all, this thing started only a few months ago.
Yes.
I had started coming in this case about few years back. One. My lord,
So
second
things
is,
have progressed. You should be happy
my
with
lord,
that.
second is the satisfaction of the arguing counsel before the honorable bench. And third is the satisfaction of the client also.
That's true. That's true. So Guwahati is a beautiful place.
I know that. I've
You,
been- I've been-
you,
I've
you
been
get
co-
to see,
Coming here.
you
for
get to
last-
have darshan of Ma Kamakhya and view of the mighty Brahmaputra.
If my lords may fix a date for hearing.
Admit the parties are duly represented. Thus, notice need not be issued.
I'm sorry, my lord. I've been told by my learned colleague, appeals have been admitted.
Have been
My
admitted.
appeal.
Our appeals have been admitted.
Our appeal has been.
Sorry, their appeals have been admitted, the main
So,
appeal.
all right. So this is also admitted.
My lord,
The
your lordship's order of 21st June 2019.
connected appeals have already been admitted. Thus, this appeal is also admitted. Admit issue notice. The respondents are duly represented. Process need not be issued. List for hearing in the month of August.
My lord, may I say something? 4 years ago, appeals were admitted, his appeals. My lord, my amount is lying with them. If your lordship kindly consider fixing it.
Your claim is pending. Your amount is not lying with them. Because you are claiming interest.
No, my lord, no.
Even the original amount has not been paid.
Amount which has been given
Okay.
to me in the impugned judgment.
Okay, understood. Understood.
That's lying with them.
That's
If your lordship
paid.
Fix, kindly fix a date. Any date coming to your lordship. May second week. Let's see.
List for hearing in on 13 June,
30.
13. We don't have vacations then.
June.
Lawyers in Delhi have that luxury.
That can be 30th June, little later than the last week of June. I'll be,
Then we can have it on 18 July.
Huh?
18th July,
18th?
July.
Okay, I think.
Yes,
No. 18 July. I'm good
Yes.
for me. I'm good. I'm good.
7 and 8, list for hearing on 18 July with the connected appeal.
All right. I should be.
Item number 9,
Wait, please, your lordship. One of the conducting counsel in this matter is engaged in another court. I pleaded a matter may be passed over for the time being, my lord.
Okay, well, pass over to me.
No, he's here.
Is here.
Sorry.
Yes.
My lord, the issue involved in the writ petition is the adjustment, I'll not use the word encadrement, my lord, I'll use the word adjustment of the petitioner's post with that of JA. Now, he was recruited as, my lord, data entry operator, same qualification, same procedure of recruitment. He came in, but my lord, data entry operator, my lord, is an ex-cadre post, there is no promotional avenue. Then, my lord, he approached the 7th CPC. The 7th Pay Commission, my lord, in its report, two directions, two decisions, my lord. One, that this post should be encadred with that of JA, and that post should not be created any further. Two, the matter should be sent to the personnel for determining the seniority.
Yes.
It went to the anomaly committee also done this. Thereafter, the cabinet, my lord, accepted the proposal of the my lord, Pay Commission and said that the matter will now be referred to the personnel. My lord, the reference to the personnel in view of the acceptance of the committee can only be for the question of seniority. Personnel department thereafter, my lord, determined the seniority, saying that his seniority would be counted from the date he is absorbed. Now, my lord, the matter was pending. I come up before my lord. There is an order for disposal of my representation, not disposal. Then again, I file a contempt, disposed of. They say, my lord, that we cannot do it because there are two reasons. One, the service rules of the department does not permit. And two, that there is an objection from the incumbent organization, Junior Staff Association and the Computer Operators Association.
Yes.
Now, my lord, this is being done by the finance department.
Mhm.
Once the cabinet had accepted the proposal, the subsequent, my lord, decision of an individual
Can
department.
we see that approval?
Lordship. My lord, I'll have my lord's attention first at 121. That's the, my lord, the Pay Commission recommendation.
Yes.
Serial number 3, my lord.
Yes.
1.12, serial number 3.
He is a one of employee.
One of employment. And that too, I'll be in the bottom seniority from the date of absorption. The commission examined the case of P.K. Sharma, data entry operator in GAD. It appears that he is a graduate and was appointed on the post in so and so. The commission recommends that since Sharma has the qualification of JA and therefore the single post of DEO should be merged with that of JA. fixing his seniority in accordance with the principles to be determined by the personnel department. However, there should be no further creation of post of DEO in JD.
Yes.
Now, this recommendation was examined by an anomaly committee. My lord, the decision is at page 123.
Yes.
General Administration Department 1.12.
Hmm.
My lord will have the second paragraph, my lord, there of para 12, Roman 12.
Yes.
As regards para 3, the committee advised JD to take up the matter with personnel department. Now, my lord, the decision of the cabinet of accepting the, my lord, resolution, that my lord would find at 127, my lord.
Yes.
It was notified on, my lord, 17/3/2017.
Yes.
General Administration Department, B.
Hmm.
The department shall take up the case of PK Sharma, data entry operator, with the personnel department. Now, before that, if my lord can just come back to page 126.
Yes.
Other department-wise issues. Other department-wise recommendations as given in chapter 14 of the Pay Commission report and is agreed to by the committee with or without modification, along with the suggestions made by the committee, were approved by the cabinet.
Mm.
So, my lord, everything was approved. It was directed to be placed before the personnel. Now, the personnel's opinion, my lord, would find at page 131.
Yes.
I am directed to forward here with the prior petition of so-and-so, which was examined in the department under the backdrop of the specific recommendation of the 7 CPC and the ROP rule so-and-so. In view of the above and consideration of the following facts, the personnel department has no objection to the prayer of the Pankaj Kumar Sharma, data entry operator, General Administration Department, for absorbing him to the cadre of so-and-so in relaxation of the appropriate rules. Then, my lord, I'll have my lord's attention at 7. Already such cases have been absorbed. Then, my lord, the relative seniority of the incumbent in the cadre may be given with effect from the date of his absorption. Now, my lord, when the matters were not being processed, I approached this honorable court. Thereafter, my lord, the decision comes at page 143, my lord. Here, my lord, while considering my case, the file notings are recorded. My lord will have in 143, the bottom, my lord, judicial department's view.
Yes.
Absence of any provision for merger the post is not a bar, as no rules would ordinarily provide for the same. It is an administrative and policy decision based on need to elevate individual hardship while keeping in view the interest of the administration. It is therefore open for the department to act upon the recommendation of so-and-so and Productivity Commission upon an objective consideration of the relevant facts.
Yes.
Then, my lord, the finance department's observation. Because, my lord, there is no financial enhancement here, right? It
There
is
is
the same.
No consequence.
No consequence, pardon. Here, my lord, would come to para 5 at page 145, my lord.
Yes.
Personnel B department twice regretted the proposal and later on reviewed the endorsement. His recruitment was done by the General Administration Department and he is well versed in his own service condition. There is no justification for claim for conversion of service. The service rule of the Assam Secretariat subordinate rules do not have any provision for such conversion. Further, the Assam Secretariat Services Association and Assam Secretariat Computer Operators Association have registered their vehement protest against the said proposal in the representation dated so-and-so and the representation dated so-and-so. Lastly, the proposal for conversion of the post of data entry operator to JA will set a worse precedent for future references to claim any person for such conversion may lead to complication of the entire gamut of the service rules. Hence, the draft cabinet memorandum for conversion of the post of so-and-so is reviewed.
Yes.
My lord, this was my case. The honorable single judge went on the premises that creation of posts or abolition of posts is the discretion of the authorities.
Yes.
So we cannot do it. But my lord, this was not a case because herein a committee, my lord, which is called to be a very high-level committee by a commission directed, anomaly committee accepted, the cabinet accepted, and only, my lord, the wordings are there, my lord, but only the thing that was referred, should have been referred, was the seniority issue. That was decided. And my lord, these associations, they will have no problem because, my lord, I'll be at the bottom. Even if today I'm there, I'll be at the bottom.
Yes.
And my lord, one provision I'll just like to place before my lord on the rules, my lord.
Can you support your contentions by any judgment? What provision are you referring to?
My lord, I'll have my lord's attention at page 4,
Yes.
section 5. My lord.
Yes.
No reason. 5(1), my lord.
Yes.
The number of posts permanent as well as temporary under each of the cadre mentioned in so and so shall be such as may be determined by the government from time to time. So, my lord, if this equivalent post is added, it would be added, it can be added under 5(1), my lord.
5-1. Yes.
This is my lord, the proposition that they have the power to create posts, abolish posts. My lord, I'm not even in a position to dispute
That's
that.
what the cabinet has decided.
Once, my lord, the sequence of events, my lord, would say,
Yes.
the only thing left was determination of seniority, and that too in the bottom seniority. And I have no grievance with that. I'm a young man, I have a, my lord, career. ahead of me.
Even ACP has not been given.
Nothing, my lord, even my pay is stagnant. I'm still on fixed pay, my lord. They're giving me a fixed pay because the revision, because that post is abolished by the commission.
Okay.
There is no revision of that post, my lord. 13 years now, my lord, I'm in the service, and after, from 16 onwards, 2016, I'm on a fixed pay. my lord.
Yes.
This is not this.
Mr. Nayak, thank for the department.
Yes.
All right, just two questions. This is a Westminster model of governance here. Cabinet takes a decision which is beneficial for the employee. Our rules do not create any obstacle. How can the departmental secretary overrule that decision?
Cabinet has not taken any such decision, Lordship. That will be clear from my affidavit, Lordship. But before that, Lordship will first see the nature of post which he is holding.
No, Secondly, it appears that this is just an anomalous situation at the moment. So that anomaly can be resolved by inclusion of the petitioner in the cadre. That resolves a lot of issues. You can't let him serve his whole life without having any prospect, any avenue for promotion, and even financial benefits. How can that be? As a model employer, can the state perceive of such a situation? You're taking his services and you don't want to give him anything.
What is the basis?
Lordship.
Is he not a regularly appointed employee?
No, Lordship.
This is
Lordship-
infraction of his
Lordship,
right
in
under
fact-
Article 16.
Lordship, I will try to address your Lordship query. Lordship, first thing is that there is an act called Assam Finance, the Management and Budget Management Act, Lordship. Fiscal Management and Budget Management. Lordship, there is a specific provision there that without following the provisions of that act, no appointment shall be made. One specific condition is there that advertisement is necessary, Lordship. Lordship, this appointment was made without issuing any advertisement.
Is this the plea before the single bench?
Illegal.
That is, yes,
Yes, on my side, Lordship, I made that
you
submission.
made that plea. Let us see your counter affidavit in the writ.
In the affidavit that is not there, Lordship will see the nature of a post, Lordship, which he is holding right now, Lordship.
Yes.
Page 91, Lordship.
Yes. Yes.
Subject to discharge without notice and without assigning any reason thereof, Sri Pankaj Kumar Sharma, son of so-and-so, is engaged as data processor on contract basis with consolidated remuneration of rupees 5,000.
Okay.
So this was his first appointment, Lordship, in the year 2007, when fixed pay, Lordship, rupees 5,000.
The bottom two lines.
The expenditure is deductible from.
This
is contingent,
issues,
Lordship,
this issues with the concurrence.
with the concurrence of the Lordship will, before that, Lordship will see that we take consolidated remuneration.
Yes.
Lordship, this is paid from contingency. That contingency was given.
Contractual appointment.
Yes, by the finance department.
Yes.
Then Lordship will see at page 98, Lordship.
Yes.
This is his appointment in a scale pay, Lordship, subject to discharge without notice and without assigning any reason thereof. Sri Pankaj Kumar Sharma, so-and-so is hereby temporarily appointment as data entry operator in General Administration Department in the scale pay so-and-so plus other allowances. Lordship, this is his appointment against the scale pay, Lordship, 2010. But important thing, your Lordship will see at page 102. This is an order dated 28 January 2011. In cancellation of earlier sanction order under reference, I am directed to convey the sanction of the governor of Assam for creation of a post of data entry operator in the scale pay of so and so for General Administration Department for the period up to 28 to 2010.
Mr. Nayak, just a
Lord.
minute.
Is equivalent to. Yes. Yes,
So this is a post, Lordship, which was initially retained only up to 2010. Subsequently, Lordship, in the next phase, your Lordship will find this was extended up, the retention was
gentlemen,
up to
this is a post created. An employee who is adjusted against a post created with due sanction of law. Can he be allowed to stagnate on a fixed pay?
Lordship, the post is a temporary retained post, Lordship. It's not a permanent post. As long as the post is there, person will.
Are you using his services till date?
Lordship will see the retention, Lordship.
Yes.
He will get salary only up to the date of retention, Lordship.
Is he being retained right now?
Lordship, he is working just because the pendency of the litigation. Lordship.
Is that so?
Yes, Lordship.
Are you sure?
That statement is not there. Lordship will see page 103, Lordship.
Yes,
103.
yes.
I am directed to convey the sanction of the governor of Assam to the retention of the post of data entry operator under General Administration Department for a period of 1 year.
Nayak, simple question. We are in 2023.
Lordship.
Where is the order of retention after this? 2015.
That is not there, Lord.
That is not there. Then why you are paying him salary?
No, this retention was only up to 2016, Lordship.
Yes, that's why we are asking
There is
you.
no record, Lordship, that the post has been permanently retained.
Nayak, then why you are paying him salary right now? Why are you using his services? It's directly an extortion by the government then.
That is a different issue, Lordship.
That is the very issue involved, sir.
Lordship.
That is the very issue involved.
Then in that case, Lordship will see that he's prayer, Lordship. He's praying for merger.
Yes,
Under the rule, Lordship, there is no such provision of merger. Learned Single Judge has clearly mentioned that.
you can create a post at your whims and caprices. And when the cabinet takes a decision that merge his service into the JA.
Cabinet has not taken any such.
All right, let us know.
I am placing the affidavit, Lordship.
Yes,
Lordship will see at page 144. This is the speaking order passed in the appeal filed by the writ petitioner, Lordship.
yes,
Page 144.
yes.
Lordship will see down below views of 7 pay, Assam Pay and Productivity Pay Commission as follows. That is the
Yes.
views, Lordship.
Yes.
Lordship will see the last 2 lines of that paragraph, Lordship. However, there should be no further creation of post for data entry operator.
Oh, further, that means this post remains.
Not
but they are-
for Lordship. Not for, already there is a existing cadre in the cadre of junior administrative assistant, Lordship.
Mr. Nayak, this indicates that no additional post should be created. But this post has been ratified. Creation of this post has been ratified by this communication. And your communications specifically say approval of cabinet. How can you say that it is without approval of cabinet? Where does your secretary deal with that cabinet decision?
Lordship, in my affidavit, I'm coming to my affidavit.
Yes. Read. Two and four. Denial of the evidence.
Lordship, I am reading the affidavit filed by the one Sri Ghanakanta Pegu Lordship, he is the Secretary, Finance Department, Lord.
J. Administration Department, please. 214. Any denial of the fact that he is not a regularly selected employee.
But that is not there, Lord. That is not there. Some names were called for from the Labor and Employment Department, Lordship, on the basis of.
Whatever was done,
Lordship.
ultimately the post has been created
Yes.
by the government of Assam.
Yes.
And he is working on that post for last 13 years on a fixed salary basis. Does any kind of service law contemplate such a situation?
Then it will come to the affidavit file.
Yes, please.
Department, Lordship, page 163.
Yes,
So I am coming to page 166.
yes. 163.
First paragraph, Lord. Secondly,
Yes,
it is the prerogative of the government in the finance department and other relevant administrative department that some recommendations of the commissions may be accepted and approved by the government and some recommendations may not be accepted.
is it the prerogative of your secretary to turn down or overrule the decision of cabinet?
Cabinet has not taken any. such-
Where is the denial, please?
No, cabinet has not taken any.
Mr.
such
Nayak, where
decision.
is the denial? Mr. Nayak, will you
Lord-
please read the pleadings
Lordship will kindly see the
The
regarding cabinet decision?
Lordship,
page 127.
Just hold on. Reading of writ petition.
In my petition, my lord.
Yes.
I'm just coming. My lord would come to paragraph,
Page number
my lord, page 70, my lord,
70.
para 18.
70.
70.
Yes.
Paragraph 2 last one reply. It is stated that in the resolution of the report of the Seventh Pay Commission, so and so, which was duly approved by the cabinet, it is clearly recommended that the prayer of the petitioner to merge the post of so and so with so and so. However, advice was made to GAD to take up the case of the petitioner with the personnel department. But in spite of the recommendation report published in the Assam Rabies Revision of Pay Rules 2017, that is after the cabinet approval, the concerned department had not
Yes.
taken any.
What is the reply to this amendment? Your affidavit.
Page
Para 18.
125, page 125, Lord.
Yes.
This is the notification by the issued by the state government. It's a 309 notification, Lordship.
No.
125.
Yes.
Lordship will see the next page, page 127, General Administration Department.
Yes.
Lordship will see B. The department shall take up the case of Sri P.K. Sharma, data entry operator with personal.
Can you read
department.
para 39
39 of Lordship.
of this very document? 126.
No, in case of P.K. Sharma, Lordship, there is a specific mention is there, Lordship. So far as other department is, that is understandable, but so far as P.K. Sharma is concerned, Lordship, it's specific.
Yes. Then
So it has, government has not taken any decision so far as Pankaj Sharma is concerned, Lordship. It was simply forwarded to the personnel department. And at the administrative department, to views of all the departments, Lordship, including personnel.
where is the view of the personnel department?
Lot of personnel department view was contradictory. At one point of time, they said for on behalf of the petitioner, Lordship. But as records reveals, Lordship, subsequently, they give contrary view against the petitioner, Lordship. It
Where
is
is
there,
that?
Lordship. Lordship will see at the speaking order passed by the authority, Lordship, in the appeal, Lordship.
For me.
What about 131? One 31.
Yes, Lordship, that is one, that is in his favor, Lordship.
Then and this is done in
Page
furtherance of
140.
recommendation by the cabinet to consider,
Yes, Lord,
right?
Lordship,
Who overrules it?
Lordship.
Who is the
Lordship
authority?
will see page 145.
145. Yes.
Ultimately, the administrative department overruled, Lordship. Page 145, Lordship, this is
Yes.
finance department observed. Lordship will see at serial number 5.
Yes.
Personnel B department twice regretted the proposal and later on reviewed the endorsement.
All right. So it is reviewed at page number 131.
That is subsequent, Lordship.
Maybe the last order which stands is in favor of the employee. What kind of employer is the state? Using the services of the employee on a fixed pay for 13 good years.
No, if that is the only ground, Lordship, then I have no case.
Then what else? That was argued. Single judge says there is no specific ground, so we are not considering. It's a fact.
His only prayer is merger of his post. along
That
with the
would,
post of
that
the-
would ultimately culminate into grant of all subsequent benefits.
Lordship. His only prayer is for merger, Lordship.
All right.
My lord, that para 18 which I pointed out to my lord is, my reply from the GAD department is at 184. My lord. They are very difficult.
Mr. Nayak, see, this expression merger may or may not be very, very appropriate
Absorb.
in the facts of the case.
Lord.
The basic issue here is there is a person who is occupying the post of a data entry operator in your department. By whatever process the intake might have happened, that is not an issue before the court. So this person has worked and he has sought the benefit of service benefits which is accrued to a regular employee. That according to him can be done. And even according to the cabinet and the 7 pay commission, by integrating the post of data entry operator with the post of JA. Is it senior
Junior.
what is junior?
Junior administrative.
Administrative assistant, clerk, basically it's a clerk.
So therefore, in viewed from other angle, the idea is to equate this post and integrate into the cadre.
Yes.
So that from the date of integration and on determination of his seniority, which will obviously not affect anybody else,
Not.
he continues to be governed by the service conditions and other pay commission recommendations so that he is brought to the mainstream. So if you bring the post to the mainstream, the person occupying the post automatically comes into the mainstream. That's the only issue here. Whether you call it merger or whatever name.
But in my humble understanding, Lord, if the synonyms of the word merger is absorption or regularization.
No, regularization is a different, completely
It is
different. aspect.
regularization, Lord. If he is seeking absorption, he is using the word merger.
No,
But in fact, he is trying for, he's absorbing, he's praying for absorption.
just a minute, just a minute.
Lord.
He may also be entitled to an order of regularization. There are orders of this court. If you have continued a person in service for so long, how can you say that we don't want you tomorrow? Even if you
Basically,
say that,
absorption of an employee who is in a dying cadre. That cadre contains only one post.
Mm.
You encadred it, you are continuing it for
This
13
is
years.
not a part of any cadre, Lordship, because.
Maybe
it's not
you
part of
created a
the
post,
Lordship.
you are
It's a
continuing
temporary
it
post,
by
yes.
sanctions.
Yes, Lord.
How long will you continue it? Tell us. What is the point?
repercussion on his.
He should have tried for regular appointment, Lord. He never tried for that. If you hold that post, he is continuing. like
Even
that.
in your sanction order, it is not said that his appointment is not regular.
I'm leaving it to your lordship, but 2-3
Yes.
points only, lordship. I'm referring to the judgment I placed before the learned single judge, lordship. At page 136, lordship. One line is there, cabinet had only approved the views of the committee and did not say that there should be merger of the post of data entry operator with that of junior administrative assistant.
Okay.
My lord, one clarification. From the date of appointment in 2010, I'm getting the scale of pay. With the implementation of the 7CPC, because my lord, there was no revision because it wanted the post to be from 1/1/2016 onwards, my lord, I'm getting fixed pay.
Fixed
So that revision has not affected my lord, my post.
Can you give us synopsis, brief synopsis?
Lordship,
please?
my lord, can I give it on Monday morning? my lord?
Sure, sure.
Lordship will only consider my judgments.
Yes, of
since announcing the
Argument heard, judgment reserved.
Much obliged.
Item number 10,
May it please your lordship. Lordship matter may kindly be adjourned for the day.
Why?
My senior could not appear due to medical emergency, lordship.
Council for petition. It is stated that arguing council, Mr. So-and-so, is not available owing to personal difficulty. List of 4 weeks.
item number 11,
But in this case, my lord, I pray first of all, my lord, for adjournment of the case, my lord, because my lord, the instruction is that, my lord, Mr. Ghar, he will address the court, my lord.
Synopsis.
My lord, he is in Delhi, my lord. He will come on 27th
It
of.
is stated that Land Council, Mr. Dhar, who would be arguing the matter, is not available today. List of 4 weeks as spread.
My lord, can it be after a week, my lord, because there is.
After,
A week, my lord.
not possible, sir. Either today or after 4 weeks. Yes,
I am available.
The similar appeal is pending, my lord.
Yes.
similar appeals.
44/23.
Registries are
44 of the.
track the file of identical appeal number so and so, analogous appeal number so and so, with this appeal and re-notify the matters after 4 weeks. Those ration card dealers, yes, I think, fair price shop dealers,
Fair.
yes.
May I please? So this appeal is against my lord, order dated 18/1/2023, my lord.
Yes,
The appellant, my lord, filed a writ petition, my lord, praying for some direction to the respondent, my lord. In fact, my lord, the appellant is, my lord, the patentee of a patent product, my lord. Prepaid, postpaid smart meters, my lord. Now, my lord, respondent had called a tender, my lord, tender. And in that tender, my lord, they are patents filing.
patent filing. This has to go to the. I don't know, I don't. This is just. Operator. Yes,
My lord, during the course of, at the motion stage, my lord, the respondent has shown a paper, my lord, by which they stated that this patent, this product has also been patented by somebody else, my lord.
yes,
I was not aware of this fact, my lord, so the learned singles,
yes,
basing on that ground, and also, my lord, that under the patent acts, my lord, the suit is maintainable.
suit is
my
maintainable,
lord.
yes,
So on that ground, my request.
rightly so,
My lord.
rightly so.
But my lord, section 48, my lord, only refers to, my lord, the rights of the patentee, my lord. Section 104, my lord, speaks for jurisdiction of the court, my lord.
Yes,
So it is either, my lord, the district judge, or, my lord, in case of counterclaim, it has to be decided by the High Court, my lord. So.
so there is no counterclaim as such.
At this is, my lord,
At
there is
this stage, there is no
no-
counterclaim.
admitted, my lord.
Then,
But, my lord, as on today, my lord, I am not in a position to claim compensation, my lord. The suit, my lord, in the suit, there may be a prayer for compensation, or, my lord, account of profit, my lord.
then,
That situation is not yet, my lord, because they have not yet finalized the tender, my lord.
so let them do it.
No, my lord.
Then
my
you file
only-
the suit.
No, my lord, my only prayer is, my lord, they may have, my lord, because they are only user, my lord. So user is also, my lord, liable under the patent section, my lord. So they may be directed only to put such condition, my lord, that my patent right may not be affected.
Then you have to go to the civil suit, civil court, sir.
That, my lord, will not affect the respondent, my lord. It is, my lord, After all, it is a state authority, my lord. They can have such condition, my lord.
Okay, thank you. Yes, Mr.
Mr. So-and-so. This intra court appeal is directed against the order dated 18/1/2023 passed by the learned single judge in WPC number 162 of 2023. Declining to entertain the writ petition filed by the petitioner by granting it the liberty to approach the jurisdictional court. The writ petitioner claims to be patent holder in respect of a smart meter. According to petitioner, the respondent, which respondent?
APDSL.
Respondent official is using the same meter in violation of the patent rights of the petitioner. Full stop. Mr. Gore has however admitted that the tender process for use of the smart meters is yet to be finalized. Full stop. It also appears that the remedy available to the petitioner would be in the form of either a compensation or an order of injunction under the provisions of the Patents Act 1970 and the civil court will be the competent court of jurisdiction to entertain such a claim. Nothing has been brought to the notice of this court to demonstrate the contrary position. In view of the above, we do not find any infirmity in the order dated so-and-so passed by the learned single judge. His writ appeal is accordingly dismissed. That's all. Nothing to the contrary has been.
It's against vacation of interim order.
Lordship. May I please, your lordship? Lordship, the writ appellant is before your lordship, assailing the order passed by the learned single judge of the dated 9/11/2022. Before going to the impugn order, lordship, I am before this court, for the action of the APDCL authority who is taking a side between the dispute, between the pre-existing dispute between the writ appellant and the respondent, lordship. That is the fact, lordship. They are taking a side against their own code, lordship, against their own rule book, lordship, violating the 4.32 of their way-live condition, lordship. There is a way-live condition, lordship, that has to be. That is the.
No, maybe, but I couldn't see the. We can have it. The next.
Who is appearing for the respondents?
I'm appearing, man.
Some contentious issues will require a little
Two minutes.
examination. We'll hear it immediately after Bihu.
Right.
Hold on, Tyndall. Till then, hold on.
The difficulty is that, my lord, around 50 households are not getting electricity because of this proceeding. That is why, my lord, honorable single judge, considering the balance of convenience, will allowed the installation, man.
Okay.
50 houses.
But the wire goes over his land.
No, not only his land. There are 3 blocks. There are 4 blocks, my lord. Everybody from 3 blocks have accepted that installation, my lord. But for this.
That's the case. They are taking the side, lordship, on the pre-existing dispute, lordship.
Rupam, given your judgment, that electricity line judgment of Rasta. Once they have decided to install, erect the towers. That is what they're. Just hold on.
After passing of this order, single judge order, the household has entered, lordship. Before that, there is no electricity connection in the premises, lordship.
Yes.
In their own rule book, lordship, 4.32 way-live permission, there is, I have given, lordship.
No, Mr. Sharma, what is wrong with the single judge's order?
Here,
Electricity is an essential commodity.
no, Lordship, that is the crux
And
of it.
Learned Single Judge says if you succeed in the writ petition, then
Lordship, here in the repetition, Lordship, here, Lordship, the learned single judge has opined page number 21, Lordship. Page number 21, Lordship.
Establishment of electricity.
51, Lordship, prima facie, the learned single judge has passed this order considering the only general power of attorney. Where it is, Lordship, prima facie, it appears that in terms with the congruent reading of clause 5 and 7.
We'll have the electricity connection removed if you succeed. Let them carry on.
Lordship.
We'll ask
Lordship,
them to remove the
okay, Lordship,
electricity.
that part I agreed, Lordship.
Then
Then this part, Lordship, there is an observation which amounts to finality, Lordship, page number 21, Lordship. Here, Lordship, learned single judge considered this order, pass this order,
yes,
pass this order considering this clause, only the general power of attorney. Whereas in the Lordship, kindly go to the
by the way, who's the appellant? What
He's-
is his authority?
He's one of the resident.
yes, I am the appellant, Lordship.
three
I am
blocks,
one
my
of the owner, Lordship. Here,
He's one of the resident of 3 blocks. He's registered
No,
for the
Lordship.
4th block, my lord. But
That- that is
electricity
not the
doesn't
fact,
go to the
Lordship.
4th block. Everybody has,
no, Lordship.
so you are erecting a tower on his land.
no,
Then,
it's a big apartment, my lord. 4 blocks are there.
okay,
He's one of the resident of one block, my lord. He is registering that the connection to the 4 blocks should not be there, my lord.
Lordship, that is,
all right,
Lordship,
we'll see it after view.
Lordship.
Let the electricity be, connection be given to all.
Lordship, there is a fact, Lordship.
Yes,
Before, Lordship, let me hard, Lordship,
we are
Yeah.
not passing any adverse order,
Lordship.
but
Sorry,
still we are
then
not.
also, Lordship, my
Yes.
grievances is against the APDCL authority, that they are taking the sites. They are
Let
taking
them-
the sites,
let
Lordship.
them.
of the
What would be the consequence?
Lordship, here the consequence is as per APDCL rule book.
As council, what would be the consequence of their action?
50 households.
Lordship,
will remain
50
without
household, Lordship, what will be
without
the consequence?
electricity.
Because they are, here, Lordship, I have Lordship, kindly give me 2 minutes,
Will you please answer the query?
Lordship.
What will be the consequence of their action?
Action, consequence of the action that, what will be in electricity connection, Lordship. Yes, okay, if we do not succeed the repetition, okay, I agree that point, but one part, Lordship, in the learned single judge order, there is an observation.
We'll dismiss your appeal, say, request the single judge to decide the writ petition finally.
No, no,
Okay,
representation- Oh, sorry, like, yes.
this is interim order.
Yes,
Mr. President.
uh,
Okay, that would be fine.
No, that will not be fine,
Then
Lordship.
all right, wait till view.
Lordship, then in that case, Lordship, my simple prayer, Lordship, there is an
Yes.
observation, the order was passed, Lordship, considering the general power of attorney.
So you wanted us to make it clear that these observations will not be a hurdle in your way
Yes.
when the writ is finally decided.
Yes, Lordship. This observation, the observation made in the in the order should not come in the way of the in the final
Final disposal of the writ
yes,
petition.
Lordship.
Dispose it. Okay, very well.
In fact, already single justice held. that-
We'll reaffirm it. Okay.
My lord, my lord.
Lordship, I'm saying that this order should not be come way. This
We
this
will
observation-
just observe that any of the observations made in this order will not prejudice the final outcome of the writ petition. Okay,
that
fine enough. Disposed of.
Deeply obliged.
Lordship. Highly obliged, Lordship.
Yes,
In view of the office note, my lord, possibly service on respond number 6 can be taken as complete, my lord.
yes,
because the-
completed.
Notice you issuing, my lord. Meantime, we have completed the pleading.
Okay, already affidavit has been filed on behalf.
Yes, my lord.
Yes.
All right. Since affidavit has already been filed on behalf of affidavit in opposition has already been filed on behalf of response numbers 1 to 6,
Yes.
comma, service upon such respondents is complete. What about 7 and 8? Other respondents have already been served.
Yeah.
Thus, list for admission,
Yes.
For admission, my lord.
list for admission. The matter be listed for admission or on a date to be notified by the registry. Okay. Yes. Yes. Next case. Oh, yeah. 12 में नहीं बजेगी। Oh, yeah. मैं within that repeat every 10 days. So if we keep on going it, little possible. 2 महीने बाद में appearing. Fresh admission here.
May I please your lordship?
Yes.
My lord, the IA was filed for consideration of delay of 77 days, my lord. If your lordship kindly produce the office note dated 16/23, my lord.
Yes.
It is so that the notice upon the sole respondent has been returned back due to insufficient.
Fresh steps.
President, my lord, I have another prayer, my lord. If the address furnished in the, given in the IA was the address furnished by the sole respondent in her WS before the learned principal family judge, my lord. I pray that I may be allowed to take steps on this address as well as in another present address, my lord.
On the request, also, the applicant is granted leave to take fresh steps with service of notice upon the sole respondent on the address furnished in the paper book as well as on correct postal address if any collected by the applicant's counsel. Notice be made returnable within 4 weeks, steps within a week.
Highly blessed.
This was in public court matters. Names of parties are not. I directed them to change it. Appeal is admitted. So it will go for hearing.
Admitted, my lord, my friend has appeared for this already.
So it will go for hearing.
My lord, perhaps the records have not.
LCR, it's been called. Is it received? All right.
My lord, may I pray be listed for orders one, because in the meantime, we are exploring the possibility of a settlement.
If you are able to settle the issues, file an application, we'll consider it.
Very good.
The appeal has already been admitted. Lower court record is received, list for hearing. Parties are represented, list for hearing in due course.
You want to explore mediation? High Court mediation?
In the meantime, you want.
My lord, yes, my lord,
Parties.
mediation is also.
Since Learned Counsel for both the sides have expressed their willingness to refer the matter for settlement through mediation. You want to obtain instruction or? we
My
should
lord,
directly-
only difficult, my lord, is a judicial, my lord, I'll obtain instructions, my lord, will place it for.
Judicial separation has been granted.
No,
Yes.
it's a judicial officer.
Who's a judicial?
My lord, the appellant.
Appellant is a judicial. You want to obtain instruction?
My lord will place it for orders. If in the meantime, you can arrive at a settlement.
Will be listed after 2 weeks again for orders so as to enable them to obtain.
Deeply obliged.
Also filed another appeal correspondent.
That's there. MAT number 8.
Not been restated.
There's one more appeal
Yes, my lord.
along with appeal number so and so.
Along with,
Deeply obliged.
you understood, no? Sorry, then after that.
Add this. Yes. Don't mention list for hearing. You don't need to mention orders. Yes.
May it please your lordship, my lord, the respondent number 7 has not been served. This I has been filed for leave to serve him in the new place of posting.
Judicial officer. All judicial officers.
My lord. Question of seniority, my lord.
Seniority.
The respondent 7 was earlier a principal judge of family court Borpeta. Now he is session judge Borpeta.
Number 5. Let them explore the rest. Why not? Yes.
So and so applicant, there is the prayer made in the IA, taking note of the prayer made by the applicant. Leave is granted for serving notice upon the respondent number 7 to be served to the registry of this court. Applicant takes steps accordingly.
All right.
May I please? This is direct application for consideration of delay of 23 days, Lordship. Connected to it, please pending, Lordship. Rate appeal number 44.
Any objection? No. Matter comes up for orders and application number so and so. seeking condemnation of delay of
23 days.
23 days occasion in filing of the connected appeal. Then counsel for the respondent has not objected to the prayer for condemnation of delay. On a perusal of the grounds set out in the application, we are satisfied that the delay of 23 days occasion in filing of the appeal, writ appeal has been satisfactorily explained. Thus, the application is accepted. Delay is condoned. Registry shall number the connected appeal and list the same along with so and so.
Read appeal number 44 of the 2023.
I will still expose that.
May please, your lordships. Lordship, herein we have this present IA is for condemnation of a delay of 234 days, your lordship.
Okay.
And we have,
What is the explanation?
your lordships, the applicants were not parties before the learned.
But
single
not
judge, your
parties.
lordship. Yes, your
So
lordship.
you have moved an application for leave to file an appeal.
That is also there, your lordship. I think only the IA for condemnation of delay has been numbered yet, although the leave application is also filed, your lord.
The leaves. Leave grant. Correct.
You are appearing for which respondent?
I'm appearing for the education department, my lord, secondary education, my lord.
There are other departmental respondents also.
Only the secondary education department is there, your lordship, and the
It's not numbered.
the petitioners before the learned single judge have been made parties.
It appears that his IA has been filed along with the leave application to prefer an appeal against the interim judgment, which is not numbered. Registry therefore number the leave application and list the matters together after a week.
Much obliged.
Is this IA number? 3168, what is that? Okay, of this one. Okay, filing number. 27.
May I pray before Lordship, here delays 50 days, 50 days,
Yes,
because
state, there is someone, some,
I may refer the paragraph 4 of the IA petition, the cause of delay.
there are counsel. from the other side. Ask them, sir. If they
Any
object.
objection, Mr. Boda?
I have no objection.
No.
If they should.
So and so for the applicant, so and so for the respondent. SIA has been filed with a prayer to condone the delay of 50 days in preferring the connected appeal. This reason for delay has been mentioned in the application. We have perused the same. The respondents counsel submit that they have no instruction to file objection opposing the prayer in the IA. In view of the above and considering the applications furnished by the applicant, the prayer for condonation of delay stands allowed. The delay of 50 days in preferring the appeal is hereby condoned. Register to number the connected appeal and list in the next week. I stands disposed.
My lord, before we go into the hearing, my lord, I will be fair, my lord. I am unable to contact my client for the last 3 months.
Okay.
But my lord, one thing, my lord, the government has filed an affidavit. Government has filed an affidavit, my lord, stating that they have almost completed, my lord, 99% of the work.
Mm.
It's a contract matter, my lord. And my lord, when it's an affidavit, because if 99% is completed, my lord, nothing remains, my lord, because I have to be fair.
So,
If
all
if
right.
we go by NG projects, my lord, we only remedy left is we can go for some damages, my lord.
Compensation, yes.
Compensation. my lord.
Yes.
So, my lord, if I harp on this, my lord, for only academic, my lord. thing, my lord.
Otherwise also, your client is not there to oppose this statement made by government.
I wanted to file and, my lord, reply to this affidavit. That is why I have sent it, my lord, but last 2 months, my lord, I'm
Your
unable
client must
to.
have realized the futility of the things.
I have advised them even, my lord, maybe that's why they are not.
Probably they don't want to
So
pay
my lord will
the
not record this. my lord.
remaining installment of fees. Yes.
Mr. Dhar has fairly submitted that the state has filed an affidavit in this case stating that 99% of the work is.
Sorry, Your Lordship, it is 95%.
95% of the work has already been completed. But appellant did not filed any rejoinder under the circumstances. No right of the.
This is all 100%.
That is so. At this stage, no relief can be granted to the appellant. in this appeal.
Appellants,
Uh,
appellants.
appellants in this appeal at this point of time. In other words, the appeal appears to have become infructuous for all practical purposes. As such, we close this appeal by granting liberty to the appellant to pursue appropriate legal remedy as may be permissible under the law. It's advised.
For for ventilating remaining grievances, if any. This one, okay.
Yes. In a result, the judgment and order dated 6/3/2019 passed by the London single judge in writ petition number 4462 of 2015 is reversed. We hold that the service of the petitioner was regularized well before coming into force of the new pension scheme and that he is entitled to the benefits of the all pension rules. Writ appeal is allowed accordingly.
You may sign, then answer. You have to sign all, every page, initially, every page. The appeal has been allowed. Yeah. First page.